All right, thank you, Mr Wilkins. Thank you, Chair.
All right, Senator Ludlam, we've got questions from you, I think.
Yeah, thanks, Chair. And I'll just seek the advice from the officers at the table because I might be wanting to wind us back in the program some. Or maybe Mr Wilkins, you can just give us some advice because it's something that I think you do know a fair bit about. I'm interested in consultations that the department's been having with industry on data retention, which has been fed into the inquiry by the Joint Committee.
So we had consultations. I'm just seeing if there have been some, Senator. We haven't had any, Senator.
Since when?
Well,
the department's been consulting with industry on this for months, if not years.
what time is it? Since about June or July last year, apparently.
Thank you. June or July. Thanks.
About the time it was actually referred, Senator, to that committee.
But before or after?
There hasn't been any since it was referred to.
Oh, I see. I'm with you. Okay. I understand there were consultations that were occurring in an earlier iteration of a data retention policy around 2009.
I think there were some informal discussions. I think the consultation was done without, for example, my authority. So it was done by the initiative of officers thinking that they would just talk and have a chat about what this might involve. So
Are we talking? Sorry, Mr. Wilkins. Are we talking about the earlier iteration in 2009 or more recently?
No.
Having a chat
about that earlier.
Yeah.
I think that was done as an initiative by officers at a lower level. They were interested in getting details about what it might cost or how it might work. So there haven't been. So I wouldn't want to elevate this concept of consultation into something that's been done with the blessing of ministers or the secretary or something like that.
Okay, that's interesting. Are we, and sorry, just to help me out here, are we talking, when you say this is just lower level officers doing this without your imprimatur, does that include the consultations that were occurring in June or July of last year?
Yeah, I don't think I...
Just going a bit off the reservation and flying some kites?
I'm not saying that I think these people need to be reprimanded, Senator.
No,
I'm just
neither
saying
am I. Well, that we could have an interesting discussion about that. But
they're doing what officers do when they take initiatives, but I'm just saying it wasn't instigated as a form of government consultation, that's all.
That's fascinating. How many meetings were there?
I don't know, Senator.
Okay, that's because these things didn't have any formal standing as such.
2, apparently.
Okay, there we go. We're making progress. There were 2 meetings. It sounds as though you might need to take on notice who actually initiated them if you're not happy to...
Catherine did.
Wonderful.
Catherine Smith, Assistant Secretary, Telecommunications Surveillance Law Branch. Those meetings were at my initiation. As Mr Wilkins said, I went about seeking the advice of industry, which I do in my daily job in assisting the Attorney in administering the Telecommunications Intercept and Access Act. It was brought to our attention by agencies that they were having issues with data no longer being collected or retained by industry, so they were essentially meetings to ascertain what kind of information they were keeping and no longer keeping so that we could advise government accordingly.
All right, thank you, that's helpful. And you chaired those meetings with internet service providers?
I did indeed, yes.
Yeah. Are you able to provide us with the dates when those meetings occurred and any such records as exist of the meetings themselves?
I could certainly take that on notice. From memory, one was, I think, March and one was September, but I will definitely take those on notice.
Yeah,
and
if you could.
As to who attended.
I suspect you won't be interested in providing me with names, that's fine, but any of the commercial participants who participated?
I don't have a problem with providing that on notice.
Yeah, that's much appreciated, thank you. I understand at some stage there was an interdepartmental committee within the government that was set up to look into that issue. Is that the case?
Not to specifically look at data retention, that was just to generally look at the need to amend the Telecommunications Interception and Access Act in the light of new technologies being provided by industry, which were doing what is considered to be going dark, which means that they would lose capabilities. That's what the meetings were for.
Yep. Data retention would have been included amidst that set of issues?
Most certainly.
Yep. Okay. Can you just describe for us how I refer to this interdepartmental committee, what its name was or what standing those sort of entities have?
I think it was an interdepartmental committee. That's all I recall it being called, but I'll certainly take that on notice.
Yeah, that's great. Were you the chair of that I don't know.
No, I was not.
Who chaired that?
Mr McDonald to my left.
Okay, so we've got the experts at the table. This is good. When did the department begin the process of drafting data retention legislation?
We are not drafting data retention legislation.
Was-
We had in the past consulted, and now we're awaiting an outcome of the Parliamentary Joint Committee on Intelligence and Security.
So at no stage were Parliamentary Council engaged to draft a bill?
We're not on data retention, no. Yeah.
There have been discussions with
Yeah,
Parliamentary
but not-
Council.
Okay, discussions were had. Just talk me through what sort of discussions were had.
This is on the broader reform, or the broader need to reform telecommunications interception legislation,
Yep.
of which data retention is an aspect. Well, that's not a reform, that's a new aspect. We've certainly engaged with the OPC to discuss the ways of which we could potentially modernise the legislation, but there's certainly been no decisions made on any of that.
I think the TIA Act has been amended since I've been here, which is not that long relative to some others, 45 times.
Yeah,
So-
well, that exactly right, Senator. And
Yeah.
I've actually talked to the Parliamentary Council himself and said that I've never seen such a gothic piece of legislation with gargoyles and flying buttresses. It is not technology neutral.
Yeah.
And so I've been asking him if we could almost think about how we would go back to square one on this and start with a clean base. So if
There
and
might be a
when,
rare point of concurrence between us, Mr Wilkins.
so if and when the opportunity arises to do something about the legislation, I hope the Parliamentary Council's done some thinking about what that might look like.
Okay.
And that's really the type of discussion that's occurred. It's at that sort of level.
All right. Was a regulatory impact statement
No.
initiated for not
No,
the broader
because-
TIA reforms, but...
We haven't gone to
No,
cabinet. or
no, we
anything.
haven't
It's not
got
required
anything
at this
like that
stage.
detail, Senator.
All right. So discussions were had with the OPC, nothing was initiated as such.
I discussed things with the Parliamentary Council. So
Yep.
it was Secretary to Parliamentary Council, effectively.
Okay. But there was no such thing as a draft of a bill that included data retention provisions.
Well, I don't know, actually.
Look, there was
Nothing
some,
that I've
no,
got.
some very vague draft provisions not to do with data retention, though.
Okay. That sounds fairly unequivocal. We'll take you on that. How often did the department brief I guess how many Attorneys General have you been through since this process started? We'll take 2 as my first guess. On how many occasions did the department brief your AG on the legislation? Actually 3.
What legislation,
There isn't.
Senator?
Or on the I beg your pardon, I'll say on the proposal for data retention.
We briefed Attorney General McClelland. We briefed on the need for reform.
Yep.
We briefed Attorney General Roxon on the need for reform, and she, you might recollect, as the person who referred it to the Parliamentary Committee.
And I saw her talking about it on YouTube.
And we've, I don't know.
No, we've not briefed.
We've not
because we're
properly
waiting for-
briefed the current Attorney General, but we will be briefing the Attorney General. And he's obviously been busy, and it's been before the committee during his... but I think he's aware of a number of the issues because he was Cabinet Secretary at the time. And
Yes,
This was
I
referred
suspect that's
to-
true. So you would just say on a number of occasions you've briefed all of your AGs during this phase of this proposal, apart from the present one, while the material's been with the Joint Committee.
yeah, it's slightly different forms and in slightly different contexts, but yes.
Did the department discuss a regulatory impact statement with the OBPR?
Who is that? What's an OBPR?
The Office of Best Practice Regulation, Mr Wilkins.
No, I didn't.
We haven't prepared a regulatory impact statement.
No, don't say prepared. Was one discussed? Was the creation or promulgation of one discussed?
Because we have to prepare that when we're going to go to Cabinet, is my understanding, and we're not anywhere near that stage
So that was
because
not
we're
a-
still seeking views from the PJCIS.
All right, thanks. Since you're here and you chaired the, I don't know whether I call it a committee or a consultative group around industry, what was the tenor of industry's response to the data retention proposal in relation, generally, I guess, to begin with? Yeah, that's to you, Ms Smith. You were there.
Well, to be honest, I need to go back to the minutes of that meeting. I understand that a lot of industry give their comments on an in-confidence basis, so I'd have to actually refer back to those before I could disclose. But generally, industry are always very keen to work with us on how we can appropriately modernise the legislation to the best benefits of law enforcement and their own interests.
All right. Could I ask you, just so that I know I've actually done it, to table those minutes for us?
Can we take that on notice?
Yeah.
Senator?
Sure. I'll play along. So you're not able to tell us what the tenor of industry's response, without naming names or breaching confidentiality?
No, I can't recollect any in particular, but I note that most of them made submissions to the Parliamentary Joint Committee on Intelligence and Security, which would clearly give their views. Yeah,
which are pretty strident in some cases. Some members of the Joint Committee have expressed at public hearings their concerns about the poor quality and the rather vague nature of the proposals put forward by the then AG McClelland in the discussion paper in which the data retention proposal is canvassed so sketchily as to not really be canvassed at all. Does the department accept those comments as fair criticism?
Yep.
Thank you, Mr Wilkins. Have you reviewed the preparation of that paper to determine how it could provide better material for committees considering issues like that?
We haven't reviewed that paper, but...
maybe let me put that in another way. Is there another copy of the proposal, or is there other material that has been put to the committee?
No. We have, yeah, we've made a number of... the department has made a number of public submissions, as well as the previous Attorney General Roxon wrote letters which were also on the public record.
Okay. Is there a reason why the department refused to provide a copy of the proposal to the committee and didn't discuss the existence of it until pressed to do so by Senator Faulkner at a public hearing? Because it took quite some time for that information to be forthcoming.
My understanding is that data retention was given attention in the discussion paper. As I've mentioned earlier, it's only one part of a greater reform of interception legislation, and we answered questions as when we appeared, both Mr Wilkins and I appeared.
All right. And just for the record, Mr Wilkins, just tracking back to your earlier comment about a root and branch review of the TIA Act, that's something that we've been involved in calling for quite a period of time. So perhaps that's something that we will be able to do down the track. Mr Wilkins, you advised the JCIS at a public hearing in November on the national security reforms in response to a question about whether data retention would be effective when internet users use an encrypted routing system like Tor. The department or the relevant law enforcement agency or whoever could, just to quote you back, could require the key to the encryption to be provided as well. Now, you probably don't have that transcript in front of you, but
I can't really recall. I do vaguely recall a conversation about encryption. But what's the question, Senator?
Okay, look, the context of the question, I'm just trying to tease out how this would work. If data retention was enforced in Australia for a period of however long, and an internet user is using an encrypted router service like Tor, it would effectively bypass the whole purpose of data retention. So firstly, because I had a surprising response from the PM's cybersecurity people the other night, is the department aware of the existence of the Tor encryption service? TOR.
Are we?
Yep. The use of those sort of technologies is normally to protect the content of communications. Data retention is about industry only collecting the information for which they are collecting for their own business purposes. Therefore, if, and I'm sorry if there was some confusion with an earlier answer I gave before the committee, but essentially an encryption key would only be used where there is an interception warrant in place, which allows you to access the content or allows the agency to access the content of a communication, and the encryption key would be used under the force of that warrant so as the information could be provided in the clear to be used as evidence or intelligence, as the case may be. Data retention, if the information is not available to a carrier, then they can't retain that information as of no use to them either.
Yeah. Could I just be clear, Tor is not an encryption service per se, it's an anonymiser.
That's right.
So you are familiar with its existence?
I am familiar with that. It's just that we were talking about encryption keys and I was just explaining
understood.
the purpose
Tor
of that
doesn't
answer.
have permanent encryption keys.
No.
and no
That's right.
temporary keys aren't
Yep.
available to sysadmins anyway. So you're basically acknowledging that it simply wouldn't apply. Data retention wouldn't apply in the case of somebody using that service.
That's correct. Unless the industry participant was able to have that information in the clear and they retained it for their business purposes.
And we've
And
just,
it's
I think,
very
agreed that it's
unlikely.
very unlikely that
That's
they would do
correct.
so. So how would you respond to the argument then that even a freely available encryption and anonymisation tools like Tor, let alone commercial ones, would utterly defeat the purpose of data retention? If somebody wanted to avoid their material being held, it's trivially easy for them to do so.
My understanding from working with the agencies is that's the reason that they want to see major reform to the legislation to give them better tools to deal with these new technologies. I can't give you the answer as to what that response would be to that.
Well, presumably those tools would need to include breaking those sort of encryption services so they couldn't be used. Is
Possibly.
that where this is heading?
Yeah.
Okay. I think I'll leave it there. That's been extremely